In today's workplace, things are evolving quickly and complexity is the norm, but clarity is a choice. This Week at Work is where leaders get practical solutions and timely insights for today's toughest workplace challenges.
Hello, everyone. I'm Phil Brandt, President and CEO of AAIM Employers Association, and welcome back to another episode of This Week at Work. AI is rapidly transforming the factory floor through employee monitoring, biometric technology, productivity tools, safety systems, and automated decision-making. These technical advances create a significant new responsibility for employers. Today, we are going to provide a practical framework for using AI to improve safety and productivity without allowing technology to become an unintended employment law liability. As usual, I'm joined by my friend and co-host Burt Garland from Ogletree Deacons. Burt, welcome back to the program.
Thank you, Phil. Always happy to be here and join in on the fun today. We've got another great program ahead. You and I love the AI topic.
I love it because it's so real and complicated, and it's not going away. And it's a new challenge. It's not FMLA,
Which is an old challenge.
Which is an old challenge. But I know people are dealing with it and they're wrestling with it, and it's just a current topic that I think people resonate with. And I think when we think about it from the perspective of the factory floor, and, taking what we have done and now how it's complicated with AI, this is going to be a great conversation. I'm looking forward to that. But I always like to start out, as you do too, with maybe a little legal discussion with Lawyer on the Clock. You want to do that?
I do. Of course. I've always got something to say on this.
All right. Well, Lawyer, you are on the clock.
All right, Phil. So this one definitely fits into the probably not a good idea category. This first one I'm going to talk about deals with two related New Jersey janitorial companies who shall remain nameless in this little description. Those two companies shared the same owner, same offices, same clients, and dozens of employees. And after worker complaints, the New Jersey Department of Labor investigated and found that the businesses had a deliberate scheme. Employees who worked 50 hours in a week received two separate paychecks, 25 hours each from each company.
Yep. Get out. Oh, so look at that scheme. Yeah.
So what did that do, Phil? Of course, it kept each employee under 40 hours and avoided the required time and a half, the regular rate of pay overtime premium.
Well, we just talked about comp time in our last episode. So this is a creative way even around comp time, but I'm going to guess this did not fare well.
It did not fare well. And so the employer had to pay $357,500 in back wages, which were for unpaid overtime and travel time, to 68 employees, plus $100,000 in fines and penalties. So this little scheme cost them almost $500,000.
Holy cow.
Yeah.
Creative, but scheme is the right word for that one.
Yeah. Separate companies do not prevent joint employer liability or controlled group liability when there's common control. And the most important of those factors is going to be the common control of labor relations. Splitting hours across related payrolls to stay under 40 hours is treated as an overtime avoidance scheme, which our members need to avoid, and I know will avoid.
Yeah, that's just not the right intention. I don't know what to say about that other than you're really taking really bad advantage of people. That's just bad.
Yep. So another one that I think it bears mentioning here is just in the last few weeks, a bipartisan bill. Get that, a bipartisan bill.
Yeah. With this group of political leaders, bipartisan?
One Republican senator, one Democratic senator introduced the More Paid Leave for More Americans Act. And that
More
bill is
paid
designed,
leave for
yep,
more Americans. All
that
right.
bill is designed to expand access to paid FMLA or family medical leave. The bill has two main parts. It establishes a 3-year competitive grant program administered by the Department of Labor. So states that enact an eligible paid leave program can apply for grants ranging from $1.5 million to $7 million. To qualify, a state program must offer at least 6 weeks of paid leave in a 12-month period for at least one FMLA qualifying reason. It can also use a public-private partnership model and provide wage replacement of roughly 50 to 67% of earnings, capped at 150% of the state's average weekly wage. So that's a lot there. The bill also creates the Interstate Paid Leave Action Network. Participating states voluntarily collaborate to harmonize definitions, administrative standards, and benefit delivery. The legislation also really what they're touting it as is addresses a coverage gap that only about a quarter of U.S. workers currently have access to employer-provided paid family leave. Just 14 states plus D.C. have mandatory programs. Remember, Missouri does not as of right now. This remains in the very early stages, and I'm going to go out on a limb here, Phil, and say that this has a very low projected chance of enactment. But I think what's more fundamental is that the conversation is taking place.
Yeah, and we're seeing shades of this conversation all around the country. We saw it here in Missouri. We've seen it in Illinois. We're seeing it in Florida. We're seeing it all around the country as it relates to more paid leave.
Yep.
Yeah,
absolutely.
And whether it's happening at the state and local level or the federal level, it's definitely a conversation that's occurring at all levels.
Yeah, well, again, I think the fact that it's been actually introduced before Congress right now is significant, and it shows that even in a bipartisan fashion, that both sides want something to happen here.
Yeah. Yeah. Okay. Well, we will keep our eye on that, even though maybe low probability, but something to keep our eye on, either this version or the next one of it.
Yep. I want to mention one more, Phil, and this is a case coming out of the National Labor Relations Board in front of a Judge Arthur Amchen, who I've actually appeared in front of before. And in this particular case, an employee was fired in September 2023 for LinkedIn posts criticizing the company's DE&I programs. The charging party here had complained internally for nearly 2 years about what he saw as gender discrimination, women-only mentoring and networking events, a poker program limited to people identifying as female, and comments during DE&I meetings that he viewed as hostile to white men. When the internal channels did not produce any change, he posted a very lengthy public critique on LinkedIn in late August 2023. He then followed that up with some more LinkedIn posts. And in those posts, he accused the company of fostering a culture of discrimination. He named specific employees and encouraged coworkers to speak up. His company then went to him and demanded that he remove false derogatory or defamatory statements without identifying which one of those statements was false derogatory or defamatory. When he asked for clarification and refused to take the post down, guess what the company did, Phil?
They fired him.
Yep, they fired him. And and later filed a defamation lawsuit against him.
Okay.
So interestingly, Judge Amchen found the posts were protected concerted activity under the NLRA. I was
already there in my mind. I thought for sure that's where you were going.
Yep. I found it to be protected concerted activity under the NLRA. The posts concern working conditions, sought to involve other employees. So,
invited others to the conversation.
And did not lose protection under the law simply because they were public, critical, or expressed strong opinions. So the judge ordered the company to reinstate the individual with full back pay and other make whole relief remove the discharge from his record and post a notice to employees. Of course, this ruling can still be appealed to the full National Labor Relations Board and then eventually into the court system. But I think in light of what we've been talking about and what we've been seeing under the Trump administration the last 2 years, year and a half or so, this case, even though it occurred well before the Trump administration came back into power, I think it represents a significant decision here showing that if somebody challenges DE&I efforts within the company needs to be very careful about retaliating against that individual simply because they disagree with what that individual is challenging.
Yeah, and I think in this case you got two complicated positions.
Yeah.
One is I'm challenging DE&I, and two, I'm doing this in a way around concerted activity, and both of those are risky business. Yeah.
Yeah, and it is. It's very risky business, and I hate to use the language, but I'm going to use it. It does put employers in a sort of damned if you do, damned if you don't position, and it gets back to what I have said repeatedly on the show for the 5 years we've been doing this, is that DE&I in and of itself is not illegal, but you have to make sure that you're doing it lawfully in order to avoid potential claims.
Yeah, I mean, absolutely. We've made that very clear. There's always an invitation to reach out to Burt or myself in that conversation to help navigate through that and do the things that you would like to be able to do in a lawful way to help you avoid that risk. But it's a risky space to wander into at this point.
Yep.
Yeah,
for sure.
All right, Burt, anything else you want to talk about before we talk about AI on the factory floor?
AI says we need to get talking about AI on the factory floor.
Well, all right. Well, let's do that. So when we talk about AI in manufacturing, we might be thinking robots and robotics, but it's really much broader than that. And I know you and I have been involved in a lot of conversations around AI over the last couple of years, and we're hearing all the stories, but we're talking about things with like cameras or dash cams and monitoring system, productivity tools, even technology that can influence employment decision. Like there's all kinds of AI influenced tools today.
Well, that's exactly right. And that's why this matters to HR and business leaders. These tools can create real value, but the legal analysis depends on what the technology collects, what it does with the information, and then ultimately how the employer is using that output.
Yeah. And before a manufacturer even buys the newest AI tool that might be attractive, let's talk about the questions that leadership should be asking themselves.
So I've thought a lot about this, and I really think it boils down to three fairly simple questions. Number one, what does it collect? Number two, what does the system do with the data, and where does it store it? I guess that's two questions in one.
Well. Yeah.
And then another one, how will the output be used in the workplace?
And that's a really important one.
Yeah, well, they all are. And I think the answers to these questions will usually tell you where the compliance issues begin.
All right. So let's say we install an AI-enabled camera strictly for the purposes of safety. Mm-hmm. At what point does a safety tool become an HR or employment law issue?
When the system begins identifying employees, monitoring behavior, measuring performance, tracking time on tasks, or frankly, producing any information that might be used for discipline or other employment decisions. I think when you get into any of those, that's when it becomes an HR or an employment law issue. The name on the box doesn't control, the actual function does.
Good point. That's a great point there. So, I'm guessing, many manufacturers, they don't think they're collecting biometric data, or they definitely don't believe they're using it in a harmful way. They just think they have cameras. And that leads down a lot of roads. Why can that assumption be dangerous?
Well, some of those systems likely identify individuals or use that biometric information in other ways, and that can trigger state-specific privacy laws involving consent, security, data transfers, retention, and destruction requirements. In fact, all of our neighbors right next door in Illinois have to deal with the Illinois BIPA law, which is the Biometric Information Protection Act in Illinois, and that law has some real teeth to it.
Yeah. Yeah. And even if, we tell employees what the technology does, get assigned consent, is there still risk, or are we covered then in that case?
So consent is always a good idea, very important, but employers might also need specific notices, retention rules, security safeguards, vendor protections, and controls over how that information is stored and how it's ultimately used. So while consent is great, it's broader than that. It's not, you can't just have consent in a vacuum.
And I think I always kind of give caution. It used to be, well, we post a sign that we have cameras, so we're okay. Kind of, it's much bigger than that today with all the things that you just went through, particularly your list of 1, 2, 3 of what and how we're using that data.
Well, if the cameras are simply just a security camera system that's connected to a drive that just retains the video, and that's it, then yeah, your camera notice is fine. But not many systems are like that anymore. They now are connected to AI and other tools, and companies are doing more and more with that video.
Yeah, let's get into some of that, because I think you're right, because monitoring productivity isn't new. We've always done that.
Right.
It used to be a guy walked around with the clipboard and monitored everyone, time studies, all these other things. But what changes when technology can track keystrokes, idle time, maybe the pace in which someone's working, their email, their internet, even employee movements? From that standpoint, it tracks you and it's measuring movements.
Well, it's the scale and the sophistication of the change. And so,
so what's that mean? Yeah.
Well, that can lead to legal obligations. A lot of states, like I mentioned, Illinois, they have these electronic monitoring notice requirements, and those rules are not identical. A national employer cannot assume one notice works everywhere.
Yeah. And, when I think about employers who have, like we're talking about Illinois today, and you have manufacturing sites or employment sites in different states, it really sounds like a headache. And it's not really a one size can fit all because of what you just said.
Definitely not. Biometric privacy, electronic monitoring, and automated employment decision laws vary by jurisdiction. And manufacturers need to know where each tool is used, which workers it affects, and what each state requires.
Yeah, absolutely. And sometimes it's even important for like non-leadership to know how those tools are being used, because I spent my entire career prior to working at AIM in manufacturing. And when we learned that we had resources, we didn't always tell everyone how we're using those resources. We just used them to our best abilities. And sometimes those things will get used without management or leadership even being realized they're used that way. For an example, this is where I think the stakes get really high here. What happens when AI moves from giving us information to influence to get hired, promoted, disciplined, scheduled, terminated, pay increases, these types of things?
Well, that's a critical line. Automated decision tools can trigger additional notice, assessment, bias, and human review requirements. And employers really need to define the role of the technology before it starts influencing those employment decisions. The employer needs to step back and think, how am I going to use this output before I start letting it influence my decisions? That's sort of what it comes down to.
Right. And I'll hear companies even say things like, "Hey, don't worry, we always have like
Right.
human oversight or final decision." If maybe if it gives us a score or something like that, that's not really going to be good enough.
Well, yeah,
Or there's some risk.
that's not a meaningful review. Managers need to understand what the output represents and question that output when it's appropriate, and also consider other relevant information. And very importantly, have the genuine authority to override the AI.
Yeah, that's another really important one. Another thing that, I know we've had conversations about is what if the tool, it appears neutral. You see this in lots of AIs. We think it's neutral or we don't really understand it, but the results disproportionately hurt a protected group. And we can't, as an employer, just say, well, we didn't discriminate. It's what the algorithm is.
Well, I think this one's a little bit in flux right now, Phil. Certainly at the federal level, based on what we've talked about on the program the last several weeks, where the EEOC is definitely pivoting away from disparate impact claims, because that's really what we're talking about here, a facially neutral system that disparately impacts one group or the other. But that doesn't
Right.
mean it doesn't exist anymore, because we still have to deal with that at the state level. So employers remain responsible for the employment decisions. And so that's why bias testing, impact assessments, appropriate notices, and documentation are becoming increasingly important parts of AI governance.
Yeah. And I think about it, the other thing I'll hear in our conversations with members is, well, first of all, most manufacturers or companies aren't building this technology
Mhm.
themselves, they're buying it. And so they're always curious about how much of this risk can be pushed back on the vendor, because we bought their over-the-counter product, if you will.
Well, Phil, you started out by saying AI is a new problem. It's not like the FMLA, which is an old problem. I guess I would answer this by saying, think of all the companies that outsource their FMLA. The
Yeah.
employer still remains responsible for the actions and decisions of that vendor. They can contract with the vendor to allocate risks, but that does not eliminate potential employer obligations or liability. So vendor diligence should address issues like privacy, consent, security, retention, storage, data use, all of those things. And employers should review the systems again whenever new features are activated.
Yeah, we talked about that in our case study at long depth
Mm-hmm.
when we did the FMLA case study, not that, but was it last month?
Yep.
Let's just talk about like supervisors for a minute, because what happens is decisions for technologies get made in a room or at a board level or at a leadership level, and then it trickles down to the rest of the group. So we can build a great policy. We can, eventually this information will land in the hands of frontline supervisors. What is it that we would want them to understand?
I think skepticism is the wrong word, but be wary of AI's output. I think as people have gotten more and more used to using AI, more people are starting to experience AI just being flat out wrong or even hallucinating about things. And so I think that the frontline supervisors need to know that an AI score is not automatically a fact.
Yeah.
Supervisors should understand the limits of the tool, how its output might be used when human judgment is required, and when HR or legal review is appropriate. So again, skepticism is probably not the right word, but I think caution is probably what's mandated here.
Yeah, and I think lots of oversight to make sure that it's a human decision, not an AI decision, kind of
Right.
going back to what we just chatted about.
Mm-hmm.
If we say let's talk about operations and HR, and there's a decision that we're going to turn on a new AI enabled system next
Mm-hmm.
month. What would you suggest to HR professionals that they would do before anyone flips that switch?
I would start by probably inventorying the system, things like, identifying which employees are going to be impacted or affected by this and in which states. I'd want to look to figure out exactly what data is collected. Where is that data being stored? We want to review notices and consent. We want to assess security and vendor terms. We want to decide whether outputs affect employment decisions, whether these outputs are simply designed to help process improvement, or is it designed to actually make decisions about people's employment? And then, of course, training supervisors. And I think, Phil, again, over the last 5 years that we've worked together, in the dozens of years we worked together before that, we always talk about it. Train your supervisors and document the compliance work that's been done. Document, train, train, train.
I want to just dive into one a little bit further here when we talk about, decide whether outputs would affect kind of like employment decisions. Where I see that get a little dicey sometimes is our initial intent of the technology was not for the purposes of employment decisions.
Right.
But then you get to the point where you're improving your business processes for lots of reasons, not just with the technology. And then you use the data from your technology to help you make a decision of, we're going to do downsizing. Who would I keep or not keep? And I'm using that data. And I never disclosed that data. We never shared that. We didn't get consent. There could be conflicts with the law. It's like, make sure that you hold true to the purpose of the intent of why you're using that system, versus let it become a secondhand or third-hand tool into adjacent decision-making processes.
Well, and if you're changing the manner in which you're using that tool that you've already deployed and people are aware of, make sure that they're aware of those changes.
Yeah, absolutely. That's, again, communication, training, those types of things. Yep. So sometimes, in my own mind, I'm like, hey, this stuff is going, and innovation is slowing us down. And other times I see it very differently. Isn't like good governance actually what allows us to use technology with the confidence that we need, so we aren't slowing progress down?
I think that's a correct statement. The goal, of course, is not to stop AI through compliance, but it's to deploy it intelligently through compliance. Manufacturers that understand their systems, build compliance before employment, and maintain meaningful human oversight are definitely going to be the ones who are better positioned to capture the benefits without creating the unnecessary legal exposure.
Yeah, absolutely. All right, Burt, we're running up against our time. I like to always kind of wrap things up with some final takeaways. What would you say are our top 2 or 3 takeaways here, Burt?
Definitely know what every AI-enabled system that we're using, know what it is actually collecting, and know what that system is doing with it. So that's number 1, first and foremost. Secondly, I would say building compliance before we actually deploy the tool and make sure we understand what that means state by state. And then I think we talked about it extensively on the program today. Never allow an AI output to become a self-proving employment decision, a fact in and of itself. We have to have that human oversight and human judgment involved in the process.
Yeah. And I would say it's just a good idea to engage in a conversation, maybe with a third party like Burt at Ogletree or myself or somebody trusted that can help you think around the corners, because there's usually a lot of enthusiasm around what the AI will do for us. And you just don't want to be short-sighted with that as a result of the enthusiasm. Burt, once again, as always, thanks for helping us break this down. It's an interesting topic and it's advancing very quickly. And I think this guidance is something that people can use. If you're interested and you need to reach out to Burt, you want to chat with him, his email is at burton.garland at ogletree.com, burton.garland at ogletree.com. We appreciate you joining us. If you like what you heard and you enjoy our program, we encourage you to go and like our resources and follow us on YouTube. You can always reach out to us at aimea.org, and we're always happy to help you. Whether you're a member or not, we'd like to hear from you. And you got one task left to do, and that is go out and be good to someone. Take care. See you next time.